Good morning, sir. You're Justin Living. And Mr. Living was previously here, entered pleas of guilty to the third-degree felony offense of credit debit card abuse and the second-degree felony offense of burglary of a habitation. The agreement was for a cap of 10 years to run concurrently on each. I've gotten the PSI as well as some letters and information that Mr. Kimler sent on Mr. Living's behalf. Has everyone had an opportunity to review all of that?
Yes, Your Honor, we have.
Are there any additions or corrections to the PSI?
No, Your Honor.
Mr. Kimler, you may proceed.
Your Honor, looking at the PSI, I'm sure the court...
Mr. Kimler.
I'm sorry, Your Honor. Looking at the PSI, I'm sure the court has noted his felony criminal history. I would just note that just looking at it, there's a lot of material in the PSI, but in closer inspection, much of this was either refused or dismissed. I think it looks like what he has is, as far as felonies, would be a burglary of a building from 2012 possession. 2012 looks like it was probably a 1244, and then another state jail case from 2017, and then the case where he has his TDC time. The only TDC case back in 2017 was injury to a child, elderly, where he got 4 years TDC. So, as I said, first glance, it looks like he does have significant criminal history. I would take issue with the characterization and the recommendations that indicated that his criminal history has continued at a steady pace since 2001, since it looks like many of the felony cases were either dismissed or refused. Mr. Living, as he stated in the pre-sentence reports, never had probation. In speaking with him, I think that he would benefit from the rehabilitative aspects of probation that are available to him. There's suggestion that he successfully go to the moral recognition therapy and successfully complete that. I think that he could benefit from that. He wants to make the changes he needs to stay out of contact with law enforcement, the criminal justice system. The letters I provided indicate he does have some support, family support out there. He wouldn't be doing this alone, so we're asking for probation in this. Of course, the court, since there are two cases, the court could defer one and give him a conviction on the other one. If the court were to defer the burglary of habitation, that would expose Mr. Living to the full range of punishment of 20 years. And then, of course, he already does have some state jail convictions, but the credit card abuse, again, is a third degree. So I believe that's just enhanced. The punishment range is just enhanced to a third degree, but the court could see fit to give him a conviction for that and still suspended and placed him on probation. But if the court does defer the burglary of habitation, his punishment range would be 20 years if he does run afoul of probation instead of the 10-year cap that he's exposed to now. The court was just to refuse probation. So we asked the court to give him probation in both of these cases.
Thank you, Mr. Kimler. Mr. Nichols?
I'll disagree with Mr. Kimler's characterization as his criminal history not being that bad. You'll note that he's been mentioned in 83 reports by Belmont Police over the years, Your Honor. And he has continuously been violating the law since 2001. There's about 15 or 16, or at least a dozen misdemeanor convictions, all going back. And all these other felonies, it's noted in the report there's many instances where cases are dropped by victims due to fear of him. And I think it's important to note that the victim in this case, in the burglary case, was threatened by this individual as he was being arrested, taken out of his garage. The individual, the homeowner had to hold him at gunpoint, Your Honor, when he found him in his garage in the middle of the night. His own explanation of that is he was running from the police and trying to hide dope, which really doesn't give him too much credit here. His explanation of the other credit card abuse case is that he got it from a dope fiend. That's his explanation. So I don't see how probation really seems to be a logical or deserved option at this point. I think that 10 years is appropriate and sufficient to both protect the community and punish his repeated behavior. I'll note in the court that as part of our agreement, I'm dismissing a violation of a protective order case. So I don't see why probation would even really be a consideration. And I'll ask court to assess the full 10 years.
Mr. Levin wanted to address the board. Does anyone have a judge?
Go ahead, sir.
I was wrong what I done, but I'm a good person. Like I can do probation. Like I ain't no bad person.
You're not.
Yes, ma'am.
Mr. Living, I have to turn 3 pages to go through your criminal history. I haven't had an officer make the kind of statement in a PSI that I got in this one in a very long time. 83 offense reports have something to do with you in just Beaumont. Don't know where else you've been, if there's any others. 83. A good person doesn't have 83 police reports that have something to do with them. A good person doesn't assault family members over and over again and get time on misdemeanors and scare them or sweet talk them or whatever it is to get out of it on felonies. That is not a good person. I understand you haven't had probation, but you were barely out of prison and off parole when you did this. I completely agree. I mean, Mr. Kimler's pointed out some decent things, but there is no reason whatsoever that I would put you back on the streets in this community for any amount of time that makes any sense to me. So in cause number 24, DCCR 0288, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of credit debit card abuse. Sentence you to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 1100, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you to 10 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These will run concurrently, which means together at the same time. I will sign the dismissal in the other case, which I didn't mention, which is the violation of a protective order where you're supposed to be staying away from somebody, and obviously you probably weren't. So anyway, that'll get signed. I'm going to hand you in each of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Kimler. Good luck to you, sir. You can go back with. Good morning. Are you Jacob Kozad?
Yes, ma'am.
Good morning, sir. You're Alejandro Uribe?
Yes, ma'am.
And Mr. Uribe, you were previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. The agreement was for 5-year deferred adjudicated probation, and I received that pre-sentence report. Has everyone had an opportunity to review the report?
We have, yes, sir.
So I guess my issues, or my only issue with going forward with this agreement is your status. You're not here, it appears as though you're not here in the United States legally, and that you've been removed before and there's an ICE hold on you now. Is that correct? So, I mean, what does given a probation do? Just give him a probation and he gets deported and it sits on, we just let it go till he comes back again illegally or legally?
I'm not coming back.
I mean, there's ways to do it, obviously,
Right.
legally, but, okay. I mean, do you think the best thing is to go forward with
I would just proceed on.
with the plea? I mean, and if you do get out, so let's just do this. We'll just go forward with the plea, and then whatever happens, obviously in federal court or with any type of new charges over there. It looks like I have been handed an arrest warrant from the United States District Court, Eastern District. So I think you will probably be taken from here. If there's a hold on you, you'll go straight over into custody, federal custody, and whatever happens over there happens. What I'm going to do is go along with this agreement. I'm going to give you a probation. If for some reason you get out during this probation period and you're here in Texas, then you obviously are required to go to probation, do everything you're supposed to, because if you don't, you could end up in prison for a very long time on this case. So what I'm going to do is find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, at this time, I'm going to follow the agreement, defer all proceedings, place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation if that becomes an opportunity for you. Obviously, if you do that, in this case, this is an excellent opportunity because you don't have this conviction on your record. And again, the other side of that, however, is if you do get out and you are here and you do not comply with the conditions of probation, you can be brought back into this court, found guilty of this offense, and sentenced anywhere in the range of punishment, which is up to 20 years in prison. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Probation will go over your documents with you today, and then we'll just see what happens. All right, you can give that back to Mr. Coleman. Thank you.
A dramatic courtroom exchange unfolds as the judge reviews a defendant's extensive criminal history and firmly rejects any request for leniency. Despite the defense arguing that many past charges were dismissed and that the defendant could benefit from probation and rehabilitation, the prosecution highlights a long pattern of repeated offenses, fear among victims, and ongoing violations of the law. The turning point comes when the judge directly challenges the defendant's claim of being a good person, pointing to dozens of police reports and a consistent record of harmful behavior. Making it clear that public safety comes first, the judge denies probation and delivers a decisive sentence, emphasizing accountability and the consequences of a life marked by repeated criminal actions. The moment captures the stark reality of how past behavior can ultimately shape a person's future in the justice system.